Hello, Benefits Companion listeners. This episode was recorded before the August 20th ruling that a federal judge struck down the FTC rule banning non-compete clauses in most worker contracts. The rule would have required employers to notify workers by September 4th that their non-competes are unenforceable. My guest on this episode, Laura Windsor, returns at the end of the podcast to discuss this recent decision. Hello and welcome to Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'm pleased to be joined by the chair of our Labor, Employment, and Immigration section here at Mullen, Laura Windsor, to discuss a couple of hot topics in employment law, non-compete agreements, and independent contractors. Laura, am I right that those are a couple of the really hot topics now in employment
They
law?
are the topics that we are getting so many calls on. I can't even kind of keep straight with it. But yes, these are probably two of the hot topics that we're dealing with right now. And I'm really happy to be with you today to talk through them.
So I understand there was some regulation. I've been hearing that, non-competes maybe are going away, and there's some ambiguity as to where the law stands as far as non-competes. So where are we with these Federal Trade Commission regulations?
It is a mess, to put it bluntly. A lot of people are asking about the Federal Trade Commission regulation. It is currently set to go into effect on September 4th, just a couple of weeks from now. And that's going to ban most non-compete agreements all across the country. That's obviously a hugely hot topic going on right now.
Yeah, that's coming up pretty quickly. Do you think most employers understand that this is happening? Is this on their radar?
No, because everyone predicted it was going to fail. Everyone said there's no way this regulation is going to go into effect. But so far, it still is. And there's three primary legal challenges right now, three cases. And not to get too bogged down in cases, but there's one in federal court in Pennsylvania, one in federal court in Florida, and another in federal court in Texas. So the Texas one is probably the one that's most active right now. That Texas court granted at least a preliminary injunction to the implementation of the rule, but only as to the plaintiffs in that case and the plaintiff interveners. The court has scheduled another bigger hearing to decide the issue further, and that's set for August 30th. But we don't even know at this point whether the court is going to enjoin the rule from going into effect at all, or if it does, it could just be limited to those plaintiffs. It could just be limited to employers in Texas, or it could be nationwide. So that's still a very big gray area. Just a couple of days ago, a court in Florida granted a preliminary injunction to stop the rule from going into effect. But again, only as to those specific plaintiffs that brought the case and not the nation as a whole or even Florida as a whole. And then the last one was the federal court in Pennsylvania, which declined to enter any kind of injunction. So as far as the court in Pennsylvania is concerned, implementation of the rule is going forward. So the current status quo is that the rule will be going into effect, at least for now.
Right. I mean, I can see how that could create some confusion among employers with this litigation. But as you said, the bottom line is, unless you're one of the plaintiffs in these cases, this is going to be the rule on September 4th. So what is the rule? So what are we looking at going into effect on September 4th?
Good question. And that is also where a lot of employers are confused. So what if the rule goes into effect? It will prohibit employers nationwide from imposing non-competes on their workers. And this includes independent contractors, volunteers, meaning that an employer cannot prohibit a worker, penalize a worker, or in any way function to prevent a worker from seeking or accepting another job anywhere in the United States or operating any business anywhere in the United States after their employment ends. So it's really broad. You cannot go work. We cannot restrict you from going to work for any other company. And as of September 4th, employers actually have to provide affirmative notice to workers who are already bound by an existing non-compete that those non-competes are not worth the paper they're written on and will not be enforced. So the rule wipes out any existing non-compete that already existed and prohibits employers from entering into any new non-competes going forward.
So that's, notice requirements are really big in your area and mine.
Oh, yeah.
Benefits. And so I knew that there was going to be a prohibition of non-competes under the new rule. But that's interesting. There's also a notice requirement. You can't just let it not enforce the agreements. You actually have to let employees know that if they have a non-compete, it's not enforceable. So that's
exactly. Now, the one big exception, I shouldn't say it's big, it's actually quite narrow, is that existing agreements with senior executives. Those are defined as individuals in policy-making positions. So think about like your C-suite personnel, your CFOs, your CEOs. If you have a non-compete with an existing non-compete with a senior executive, that will remain in effect, but you cannot enter into them in the future. So if I have a non-compete with my chief sales officer, that will be able to remain into effect, but I can't enter into a new agreement with a new chief sales officer going forward. And the law also permits non-competes in the context of a sale of a business, but really, that's it. Existing agreements for senior executives and in the context of a sale of a business. Other than that, non-competes would be banned going forwards and retroactively.
Okay, so what if the rule does not go into effect? Would non-compete still be permitted?
On a federal level, yes. I mean, the import of this Federal Trade Commission rule is that it would create this nationwide ban. But if we don't have that federal law, then you have to go back and look at state law. And you and I are sitting here in Virginia, and here in Virginia and in many other states, there's a ban on non-competes for so-called low-wage workers. And I really mean that that is a misnomer. We are not talking about minimum wage workers here. In Virginia, low wage is defined as anyone who earns less than the average weekly wage for the Commonwealth of Virginia. Right now, that's about $74,000 a year. So in Virginia, you cannot have a non-compete with anyone who is making under $74,000 a year. But again, that is a moving target. It's the average weekly wage. Other states do ban non-competes altogether already. California, North Dakota, Minnesota, and some ban them if they're impermissibly broad or they're unreasonably interfering with the employee's ability to earn a livelihood. So state laws are all over the place. So if you don't have the federal law, then you have to look back at state.
Okay, so this is really kind of a mess, as you said. So what are you advising clients?
Generally, I'm advising them, if you don't need them, don't use them. I always ask clients, what is it that you're really trying to accomplish? If it's to protect your customers from being taken and going to a competitor, then use a customer non-solicitation agreement. That's not the same as a non-compete. If you're concerned about your confidential information falling into wrong hands, then use a non-disclosure agreement. Those kinds of agreements that are not prohibiting an employee from working, they're only permitting them from taking your stuff, is a lot easier to deal with.
So maybe non-competes all along have been really too broad of a brush. That's really interesting.
I think so. And I think, courts obviously don't like the idea of employers telling their employees that they can't go work someplace. Courts want that ability for mobility amongst workers. So think about what it is that you're trying to protect. And I bet we can formulate an agreement that's not a non-compete that's going to cover those interests.
Yeah, I think that's really helpful advice. So let's turn a minute to independent contractors. In the benefits world, this is an issue for us where we have employees, our plans say that employees are eligible to participate in the plan, and we've classified somebody as an independent contractor, and then it turns out, for years this person was an employee and should have been getting benefits under the plan. Or for the Affordable Care Act, where
Right.
you have to offer coverage to full-time employees, and there's someone who actually is a full-time employee, common law employee, and not an independent contractor. So it comes up in the benefits world. So what are we seeing? What's happening in the world of independent contractors right now?
This is just such an area that is still consistently misunderstood. And I struggle with kind of wondering why it's so misunderstood. But just because you call someone a consultant or say, oh, they're a 1099 worker, the law does not necessarily consider them independent contractors. And this is just an issue that is running employers into huge misclassification lawsuits, Department of Labor investigations, IRS investigations. It's an issue that's covered by state and federal law, and it's really, again, all over the place. So, it's something that just because an individual says, oh, I want to be a consultant, I want to be an independent contractor, the law might not treat them as such. The law might say, you might think you're an independent contractor, but you're really an employee. And that, again, it varies by state law and federal law.
I have encountered that many times where an employer, well, we don't want to pay FICA, or we don't want to treat this person as an employee. So let's just change the employment agreement to say that they're an independent contractor.
That's right.
As you're absolutely right. It doesn't matter what you call somebody. It's what they are. It's what they are under the test. So as you said, we're sitting here in Virginia. What's the current law in Virginia?
Well, Virginia, we got a relatively new statute in Virginia just a couple of years ago, and it provides that individuals performing services for a company are legally presumed to be employees. And for those of you law nerds out there, legal presumptions are very hard to overcome. You are presumed to be an employee, and it's up to the company to prove that the individual is actually an independent contractor. And how do you make that proof? Well, you use a really complicated 20-factor test that the US IRS uses, which ironically is different from the test that the US Department of Labor uses. And in order to prove that that individual really is an independent contractor. Now, I will say most of the states have one common denominator in the factors that go into being an employee as opposed to an independent contractor, and that is control. Okay. The more control that the company exercises over the individual, the more likely they're an employee. Are you telling them where to go? Are you telling them what to do, when to be there, how to do their job? Are you evaluating their performance? Are you setting their schedules? Are you giving them a desk, a computer, an email address? Are they filling the same types of roles that your W-2 employees are performing? Those factors of control will go in favor of that individual being an actual employee as opposed to an independent contractor. Yeah, so it's a lot. It's all based on control, though.
If I hire somebody to paint my house, that person paints other people's houses. They show up when they say they're going to show up. They use their own paint and tools and equipment and paint the house, and I pay them for the job. That's different than having a building with a paint crew that only works for that one employer and receives all of their tools and equipment from that employer, and their hours are set by the employer, and they're told where to go and when and how. And those, I know I'm really, again, painting with a broad brush here, but I always just think of that. That's really, is a person doing services for the public and you're not really controlling them. You're just paying for the result, or are you directing them and providing them the equipment and tools? It's the economic.
That's exactly right. That's a perfect analogy. I always use the example of my HVAC repair person, the guy that comes to your house to fix your heater. He comes when he wants. He leaves when he wants. He brings his own tools. He does the job how he wants to do it. That's a vendor. That's an independent contractor. And so that really is the difference. And I'll mention a lot of companies they'll say to me, oh, but don't worry, Laura, we have an independent contractor agreement. We're all on the same page. And independent contractor agreements are essential. Don't get me wrong. You have to have one if you think that you're going to have an independent contractor. But that is like the tiniest of relevant factors. What the courts will look at, what the Department of Labor, the IRS, what they will look at is the actual nature of the relationship, not what's on the paper, but how are you interacting with each other?
So what's your advice to clients regarding independent contractors?
Don't do them. Don't use, it's got to be a really, really specific and narrow set of circumstances in which the individual should be classified as an independent contractor. If they're coming in as a hired gun to work on a very specific project and then they're out, if it's very narrow, if it's something that no other employee in the business is performing, then we can probably be relatively safe. But I get very nervous about it because the penalties are just so severe.
Yeah, in the benefits world, years ago, before there was a case with Microsoft, and where dealing with employees who were classified as independent contractors, but they were actually employees. And then they sued under ERISA, and that they were entitled to benefits because they actually were employees. And so in all of our plans now, instead of saying you're eligible for the plan if you were an employee, we say you're eligible if you are classified by the employer as an employee, regardless of whether the court or administrative agency determines that you're actually a common law employee. So instead of just saying now employees, we use that language, we call it the Microsoft language, to protect employers from a misclassification resulting in somebody receiving or not being excluded from a plan when actually the terms of the plan say they're entitled to it. So from that, that's a benefits issue that we have with the independent contractor. What are other penalties and concerns with misclassification of a worker?
I think a lot of employers think that, or companies think that the only penalty is, oops, I didn't pay the employer portion of FICA. Well, that's just like the scratching of the surface. There's certainly back taxes. There's certainly the employer portions of FICA. You hadn't been contributing to unemployment. You hadn't been making Medicare contributions. Maybe this individual was working overtime and you didn't pay them overtime. If they were classified properly, they would have gotten health and dental and vision insurance, and they they didn't. So that's something that they're entitled to. It's really kind of anything that that individual would have received if they had been properly classified as an employee, as opposed to being misclassified as an independent contractor. And that's the law in Virginia, is that, the damages would be anything that they would have gotten had they been properly classified as an employee. And keep in mind also, this is looking back 3 years. And so if you have one of these, quote, long-term consultants, which is always a bad idea, and you could really be adding up those numbers pretty quickly. And God forbid someone gets in a car accident while they should have been on your benefits plan and they weren't, because maybe then you're paying for their medical bills. So it can really, there's a lot of potential downside to this. And so I always advise clients to please tread so carefully on this and be as sure as you can that this really is that hired gun or that HVAC repair person or your house painter type of analogy.
Yeah, and it's even, in a 401k context, if your plan makes employees eligible to make elective deferrals and you don't offer someone or you exclude them from the plan, the correction under the IRS correction procedures is not to get money back from the employee that they were paid. It's the employer has to make a corrective contribution to the plan. So if you have a bunch of workers who are independent contractors, but they're actually employees, and you don't have my Microsoft language that discussed earlier, that could be a significant issue. You could risk plan disqualification because of an independent contractor issue. So it's way beyond FICA to get this right. So Laura, I know
we've scared people enough.
I know. We should have done this one in October for Halloween. So I know there's a lot more we can talk about, but this really highlights these complex employment law issues and why companies need to tread carefully.
Yeah, it really emphasizes also the overlap between what you do in employee benefits and what we do in general employment, and how one mistake in one of our little areas could have ripple effects that affect benefits and general employment. So, this is part of our job that we enjoy a lot, which is helping clients understand these complex employment issues and help them before they run into trouble with the courts or administrative agencies. Think of it as kind of going to your doctor for preventative medicine checkups as opposed to running to the ER for surgery. The more we can do on the front end to get it right, the better off we are.
So Laura Windsor is back with us. This podcast was recorded before a very recent court decision, and so we're adding to the end of the podcast an update. So Laura, tell us what happened.
So this falls in the category of never a dull moment to be an employment lawyer. And this is why I love what I do, because the courts definitely keep us on our toes. So as we mentioned in the original podcast, there were 3 federal court cases pending that would have an impact on whether the Federal Trade Commission's non-compete law would go into effect. There was a Florida decision that enjoined the rule, but only as to the plaintiffs. There was a Pennsylvania decision that did not enjoin the rule and was letting the rule go forward. And then there was a Texas decision that had initially prohibited the rule from going into effect, but only as to the named plaintiffs and the interveners, but was reserving judgment on a more fulsome decision by the end of August, which the end of August came a little earlier than expected. So the case that we're talking about is Ryan LLC versus the Federal Trade Commission. It's out of the Northern District of Texas Federal Court in Dallas. And as you mentioned, Brydon, what the court held in a nutshell is that the Federal Trade Commission final rule on non-competes cannot and will not go into effect. So to be clear, that federal law will not go into effect on September 4th, and it will instead, we are going to revert back to the state laws. So I think the interesting thing about the court decision, and not to get into the weeds on it, but I think it is really relevant, is that the court held that the Federal Trade Commission exceeded its authority granted to it by Congress. It exceeded the scope of the Administrative Procedures Act, and it acted arbitrarily and capriciously in enacting this non-compete rule. And so ultimately, the court concluded that the FTC promulgated the rule in excess of its statutory authority, that it is arbitrary and capricious, and that therefore, under the Administrative Procedures Act, the court, quote, must hold unlawful and set aside, end quote, the FTC's rule. There was an argument that perhaps this rule should be enjoined only as to the specific plaintiffs in the case, but the court also rejected that argument, noting that the Administrative Procedure Act does not contemplate party-specific relief. The Fifth Circuit, which is where the Texas court sits, and many other circuits across the country have held that when something violates the Administrative Procedures Act, whatever that decision to set the rule aside must have nationwide effect. So in other words, the court basically held, listen, I've got no choice. Not only is this rule unenforceable, not only does it exceed congressional authority, but my ruling on that must apply nationwide. So let me pause, Brydon. That's where we are.
So what's next? Is this the end of the story, or
Of
what's
course
happening?
not. It's never the end of the
Right.
story. Never the end of the story. So, as many of our listeners are probably familiar, I mean, there's an appeals process. So this could be appealed by the administration up to the Fifth Circuit Court of Appeals. Candidly, I believe the Fifth Circuit would likely rule in favor of enjoining the FTC rule, and then arguably it could go up to the Supreme Court. And, obviously the outcome of the election in November will have a significant impact on what happens with this. But as it stands right now, I think we can be fairly to very confident that the FTC's non-compete rule will not be affecting us anytime soon.
Okay. Well, Laura, thank you for coming back and providing that update. And
Absolutely.
listeners, thank you for tuning in. And please subscribe to the podcast to be notified when the next episode posts. Thanks for listening.